I'm Amanda. I'm out of the San Diego, California office of Ogletree Deakins, and I've been practicing employment-based immigration for around 20 years. I will say that the past, I guess it's now been a full 10 months, have been the bumpiest of all of time periods within immigration. It feels like a roller coaster, and it's been a little chaotic, which as an attorney, I like things to be much calmer. I like to be able to rely on the laws, the regulations, and this has definitely been a different flavor. So today we're going to talk about largely H-1Bs and then also immigration enforcement actions, unannounced visits. So a lot of the actions you've seen on the news involving immigration and customs enforcement. Basically how an employer deals with that if they do show up. So I guess off the top, let's talk about this presidential proclamation. So this was effective September 21st, 2025, 12:01 a.m. He signed the order on a Friday and it became immediately effective. The proclamation was not as precisely written as I think most folks in this area and in this profession would have liked. So it used a lot of words interchangeably and it left a lot unclear. That evening what we took away is that it could be a travel ban. It could prevent folks from returning to the United States who were sponsored H-1Bs if they couldn't show that this $100,000 fee had been paid. We also had a lot of concerns around new H-1Bs. They use the term new. So does that mean folks who maybe have not yet secured an H-1B? So they're students maybe in the US, they're transitioning to an H-1B cap case. Got a lot of nonprofit clients, cap exempt clients. What did it mean for them? The framework it's in place for 12 months. It is renewable, so they are supposed to evaluate it and possibly renew it. And within the proclamation, it also charged the agencies basically to figure out how to implement this proclamation. And it also instructed Department of Labor to do some work on prevailing wage levels, which in short means increase those, make the H-1B more focused on very highly paid positions. And he also instructed Department of Homeland Security to change the way the H-1B cap lottery, so the random lottery process, to prioritize those that are more highly skilled, more highly paid. So make it less random. So post Friday evening, when all of this happened, there was a lot of additional information that was shared. Some of it through X or Twitter, which is never where I want to go for my legal guidance, but that's where some of the clarifying information came from. There were FAQs, but this all was kind of released post-proclamation, in my opinion, in an effort to try and clear up some of the ambiguity that was present in the proclamation. The most recent guidance that came out was October 20th, and that came from USCIS. So U.S. Citizenship Immigration Services, they're the benefits arm of immigration in the States. They provided a little bit more clarity that I think helped a lot. It also uncovered a few areas that I think are important for employers to understand from a compliance perspective, that there's some risk, even though those that have H-1B status in the States, we thought they were free and clear, we were all good there. If there are certain issues where there's violations of status and it triggers a case to be approved a certain way, there's a chance that that fee could apply. So what I tried to do, what our firm tried to do, is put together some charts to outline what cases could be subject to this fee, what cases are not subject based on the guidance thus far, and kind of what we don't know with 100% certainty yet. So there's a lot of immigration terms in this. And I'll explain a few. So what does consular notification mean? That means we're filing this case, an H-1B for someone, and requiring them to activate that approval, which means they either are outside of the country or we're having them leave and come back in, post-visa stamp or using an existing visa stamp, which is that travel document, kind of their ticket in to the United States. This consular notification piece from the recent guidance that came out on October 20th really seems to be kind of the trigger for whether or not that $100,000 fee is going to apply. So for folks who we're filing cases for that are outside of the United States, it appears it may apply. And this is for folks who hold H-1B status already or for new H-1Bs. There is specific language within the guidance that does refer to an H-1B visa stamp as though that may be a carve-out. So we have situations where you have somebody who's transferring over as a new employee, the employer's sponsoring their H-1B. You, for whatever reason, through legal analysis, has determined that the consular notification is the way that we have to file this. But they hold that valid H-1B visa stamp in their passport. They don't have to go get a new one from a U.S. consulate or an embassy. It appears they may be exempt. An employer may be exempt from paying that fee in that situation. However, our firm has filed those, and we have gotten RFEs requesting either the fee or basically why you're exempt from the fee. So it's still gray, and I don't think it's 100% clear. And I think that's also the case with those that are visa exempt.
So I have a question on this. Clients or businesses that are wondering how this is going to apply to brand new H-1B applicants that are coming up next year.
Yeah, and I think with the new guidance that came out from USCIS, we've got a little bit more clarity on that. In reading the guidance, if we have students and we're looking at the H-1B cap lottery for this upcoming fiscal year, if it is possible to file their case as a change of status, meaning that they get selected in the lottery, let's say they're a student, we can file, post-April selection, and their status is automatically changed to an H-1B, the $100,000 fee does not apply. However, if we have folks where that's not a possibility for, if we do the legal analysis and there's not runway to keep them here in that capacity, or they're outside of the United States, maybe they're a new hire that was recruited and you want to bring them in and this is your opportunity. If they are outside of the states or they require, that activation piece to go out and get the visa stamp and come back in, it appears that $100,000 fee does apply. So I have a lot of clients who are asking kind of, what do we do with this? How do we plan? And, we've really been saying, you do really still want to determine who is the pool of folks that you do want to try to do these registrations for, and then do the legal analysis. Who is going to be eligible for a change of status, and then who is not going to be. And then, of course, the business decision comes, is it possible if the fee is required to pay this for these potential sponsored folks, or is that not, feasible from a business perspective? There is the possibility of applying for a national interest exception, which I'll get into, and there is some unknowns on that too. But we do know that if someone is here in the States, they hold H-1B status, there's no violations of their immigration status, meaning that they're doing what they need to do to be here, working for the correct employer, being paid, no overstays, there's no gaps longer than what's permitted by law. If they're maintaining their status and it's just a seamless change of employer, extension in the U.S., or just an extension of existing employees, amendments, maybe somebody took a new job offer within the company and we need to amend, or maybe they moved work sites. As long as we can do that seamlessly in the U.S. and we can extend their stay, that all is not going to be subject to that $100,000 fee. And this is the part that I think with the new guidance, it became, it's really a compliance thing, I think, for our clients, our business clients, and I think for individuals as well, clearly. But a lot of, with the H-1B, it's employer, it's position, it's location specific. You know, post-COVID, there's so much remote work. And so when we're structuring these H-1B filings, we're listing their work site. If their work site is their home, or, you know, they're hybrid, or, you know, if their work site changes before an amendment's filed, that is an issue. You know, prior administrations, you know, they would forgive those blips, you know, those missteps, and still approve. You know, the concern is with this administration, they won't. And if they don't, that's going to trigger a consular notification approval, and then we get into the $100,000 fee issue. So, you know, maintenance of status, both for the sponsored foreign national employees, and then from the business perspective, the compliance pieces, they're really important. Yes. Yes. Gotcha. Correct, yes. And I think too, like, so we're talking about, you know, cap subject, and then we also have nonprofit, cap exempt employers. So that has cleared up some of this concern with them. Because I had many, you know, I've got university clients, I've got healthcare clients where they were just kind of holding, you know, can we recruit? Can we bring people in? Can we change their status? And it was a little bit unknown. But with this new guidance, we do have more clarity on that. And we have been successfully filing those H-1Bs, changes of status, and those are being approved. Correct. Yeah, in this space, you know, once it's approved, I mean, they can apply for a visa stamp, they should be able to travel, but it's that change of status section. And that's a good point, too, because once that's filed, they need to stay put. They need to stay in the United States until it takes effect. So any intervening international travel can throw that off. Yeah. So then let's talk a little bit about where the fee's not going to apply. So we talked about consular notification. If we have consular notification approvals that were filed, approved prior to, well, actually filed, I'll say filed, prior to that proclamation effective date, even if they were approved after, those are not going to be subject to the fee. So if people travel, come back in, that's not going to trigger it. And this applies to last year's cap approvals that we're still kind of getting those in. If they were filed for consular notification predates this proclamation, that $100,000 fee does not apply to those folks. And then as we talked about, change of status, extension of status, amendments, change of employers, as long as we're good within their, you know, there's no violation of status, you know, we're pretty safe in the fact that it's not going to apply. Now, with the fee, you know, the exception, national interest exception, this is where they say, you know, either the fee gets paid or you can apply for a national interest exception for the sponsored individual. If approved, then the fee wouldn't apply. And I think there's framework that has been put out. This came out in the recent guidance, and it is helpful because it at least gives us something to look at and kind of operate around. But we don't have real data or statistics on, you know, how successful these are. You know, this is a different, I think, twist on national interest exceptions or this national interest argument. I was familiar with them under COVID when we had to get visa stamps for folks and there was travel issues. This is a different kind of animal. It seems to be focused on specifically the H-1B worker. It also has a component where they're saying you can't find an available American or U.S. worker to fill the role, so it seems that you have to provide some type of, you know, analysis, recruitment results, something to support the fact you can't find someone locally without sponsorship. You know, the H-1B worker doesn't pose a threat. And then the other piece, that requiring the petitioning employer to make the payment on behalf of the H-1B worker would significantly undermine the interests of the U.S. It just, the way the whole, it's framed in a way that it seems like it's going to be a very difficult climb.
Have you seen any successful national interest exceptions?
In the firm, not yet. We've got a few that have been submitted, more nonprofit, healthcare, focus. Those are still pending. And so this kind of rolls into what we don't know. So we don't know timelines. How long is it going to take to get one of these out? Is there a possibility to expedite it if there's an urgent business need from an employer to get someone here? We don't 100% know how they're going to be viewing it. Is it employee specific? Is it, could it be employer wide? Could you argue that the employer, national interest employer, that can carry the day? And we don't know exactly who's reviewing them. I mean, we know it's Department of Homeland Security, but we don't know who's been delegated this task. So the framework's there, that is helpful, but we don't quite know what they're going to do with it. Time will tell a little bit on that one. And the other piece that I mentioned previously that we don't quite know yet is those issues where we've got an H-1B we're looking at filing, and there are either status violations or maybe the person's outside of the U.S., but it's not cap subject. They've previously held an H-1B. But they have an H-1B visa stamp in their passport, so they can enter as soon as they get an approval. It's not quite clear if those are exempt from the fee or if they're still required to pay the fee. So that's still, I think, gray, and we're still working through figuring out how that's going to roll out, because we are getting RFEs. There's been responses put in, so we're still waiting for some decisions. And briefly, I wanted to kind of talk about litigation with the proclamation. So there are 2 lawsuits pending at this point in time. I think the notable one, the other one's great too, but the notable one is the U.S. Chamber of Commerce. I mean, I think historically it has been more conservative-leaning business interests, and it did kind of take a break, I think, from where we thought. We didn't know if it was actually going to get filed, but they did file suit, against the Trump administration, asserting that they didn't have the authority to do what they did. We're kind of waiting to see how it shakes out. Obviously, it's still pending. The relief that's been requested is to enjoin the implementation of it. We don't know. There's this little bug that keeps flying in my face. We don't know if that relief is granted, whether it's going to apply only to chamber members or if it could be the potential of a nationwide injunction. And Kathleen brought up a good point that the Supreme Court did come down talking about nationwide injunctions, different context, but it'll be interesting to see how it shakes out. The other lawsuit pending in the Northern District of California, we're still just kind of waiting to see what comes from those. So, I think at this point we're just trying to operate in a world where this is the rule, and so we're trying to plan and guide clients effectively with that. So the other piece that's coming around with the H-1Bs is the potential for weighted selection in the lottery process. So there's a proposed rule that was put out. The comment period on a portion of the proposed rule has closed. There's still some that's outstanding. I think it closes at the end of the month. But it is proposed. We don't know if it will actually get pushed through in time to really impact this year's cap lottery. But if it's not this year, I think we could see this continue on, and it could still be coming to play next year. But what this means, so the H-1B cap lottery, it's a random selection process. Supply outweighs the demand. You've got around 85,000 cap numbers. Master's cap, obviously you've traditionally got 2 shots. Now they're changing it to make it more focused on highly skilled, higher paid positions. So it is changing the randomness in that respect. It's proposed to be implemented this coming fiscal year. The timeline, in order for it to actually go into effect, the final rule will need to be published 60 days in advance before the cap kicked off. I guess they could monkey around with those dates a little bit. If it were an emergency rule, that could have immediate effect, but that really, I don't see like the national security interests with this. So I think that we may see them move more quickly, but time will tell. But to explain it a little bit, the positions, if a position basically is leveled at a level 4 wage, so the Department of Labor has a salary survey that's utilized frequently for H-1Bs, 4 wage levels. If the position is a level 4 wage, so we're talking very senior level positions, leads, maybe direct reports, that type of level, you would have 4 entries, 4 shots at securing a cap number. So your name would get dropped back in if you weren't selected once, get dropped back in again. So that's the same with level 3, level 2, level 1. So level 1 and 2, for your students to H-1B, generally you're seeing them level 1 and level 2. Not that their positions aren't highly specialized, but they're embarking on their career, so they're just going to be coming in at a lower level. They still have a shot, but the odds are very different than what they were. So with this, it does change how the H-1B lottery may shake out if this does actually get implemented.
And has something like this been tried before?
Yes. 2021. I think I got the year right.
And
but
what happened?
it didn't go. and then they ran out of time. So then, we had a new presidential administration come in. I think that it's back, and I think that they've learned from their previous mistake. They waited too long. So they started it right out the gate. They started a lot of things right out the gate that I think they wanted to get done the first time around, and then starting them earlier, I think that they think there's more chance to get it, have success with it. But it was litigated, and it did get halted. So with this as well, we do anticipate litigation, because it's a big change. So with that, I'm going to kick it over to Kathleen, who's going to, oh yeah, sorry, go ahead.
We do.
Oops, sorry, there. Mm-hmm. Well, I think it's around the position that they'd be taking. So, if they're gaining experience with you as an H-1B that makes them more valuable and coming in at a higher level with another employer, then yeah, I think that could be, from looking at your planning perspective, something to consider. Mm-hmm. Mm-hmm. Sure. I think it probably, that's a really good question. I think it probably goes towards the experience that they're going to gain and making them more valuable for, the next employer. I think whether J1 or H1B, I don't know if that necessarily, carries the day. With an H1B too, that, not subject to the cap, so they'd still go through the whole cap process with a public, not-for-profit company. So there's still that hurdle they have to jump through. But, it's good thoughts for counseling, folks into the next step, because I know it's really scary for students right now. Yeah, yeah. It is. Yeah. I I know. Yeah, I mean, and there's more coming out with students that we're waiting on, and finite periods of stay, what that's going to look like, and what options students have, for pursuing other degrees. Yeah, there's a lot. There's a lot. Yeah. Over to you.
Okay. All right, I'm going to touch on the ICE actions and also unannounced visits, which we are reading and hearing a lot about in the news. So essentially, there are really 4 work site enforcement actions that we want to educate you about. One is the administrative warrant. The second is the judicial warrant. The third is the ICE I-9 audits, and then a site visit. So we'll talk about each one of those. They're each different. We'll start with the administrative warrant. And what is an administrative warrant? So an administrative warrant is usually issued by Homeland Security. Looks very official, looks very much like a judicial warrant, but it differs in some significant aspects. That's very important. It's a non-criminal warrant. It's issued by the Department of Homeland Security. It's DHS Form I-200, which is a warrant for arrest, or Form I-205, which is a warrant of removal or deportation. Usually there's an individual focus, probable cause to believe individuals are removable. Now here's why it's important, the difference between an administrative warrant and a judicial warrant, is that with an administrative warrant, ICE cannot enter, Homeland Security cannot enter without consent. So the employer has to consent. Typically, they will arrest, with the consent of the employer, arrest the person named in the warrant, locate the person if they're in a public place, but you can decline consent.
One really quick thing, just because I'm in the state of California. California, there's, of course, something additional that the state has in place. But with consent, if an employer were to make the determination that it was going to consent, that would actually violate state law. So just if anybody's here, has operations in California, just something to be aware of, that there is that difference, which I think is the only state that has that.
And then the second is a judicial search warrant. Now this is an official warrant that will be issued by a court. Oftentimes you'll see the name of the court on the front of the pleading. You'll say United States District Court for the Central District of Utah, for example, and it will be signed by a judge. And we'll get into sort of having a response plan, and that person who's going to be the point of contact, the first person who would experience officers either with an administrative warrant or a judicial warrant, what they should look for. Because again, both look very official, they're both government forms, but on the judicial search warrant, you want to look for the name of the court, and you want to look for it being signed by a judge. The other thing that you want to train your person to look for, if you're the person who's looking through the judicial warrant, it should say the date, time, and place. And the date that it's being executed needs to be the date that they're showing up during the time period and at the right place. They've got the address wrong. You're going to want to look for those things on the judicial warrant. These are usually focused on locating records relating to criminal activity, an individual who's ordered removed and failed to depart, individuals who re-entered after removal, employers continue to employ individuals after ICE confirmed that they were unauthorized, or the employer knowingly hired unauthorized workers. So it's kind of a pattern and practice. The authority that a judicial warrant provides is officers may enter private space. They may search for evidence of crime, a specific location, time restriction, specific types of evidence. The judicial warrant gives them specific authority to enter private spaces, authority to search records and seize files and computers. Typically, this is not a situation where you can or cannot consent. We recommend if there is, a judicial warrant, as with a search warrant, that's response team, that initial contact person can invite, the officers to sit and wait while they contact the team, the management team, or the people who can address their concerns. But with a judicial warrant, unlock the doors and let them in to execute the warrant. The third administrative process here is the I-9 audit. An officer, typically in plain clothes and not in uniform, but will certainly have official credentials, will present a notice of inspection, and typically you'll be asked to provide I-9s. It may also request business records related to those I-9s.
Yeah, the subpoena would.
You have 3 days to respond. You may be asked to waive that 3 days. We recommend that you do not, that you take the full 3 days in responding to an I-9 audit.
With those, just really quick, if you don't mind.
Go
With
right
the
ahead.
I-9 audits, too, getting legal counsel involved as soon as it's received is really highly recommended. I work in San Diego with more of a laid-back attitude, so I've had a lot of success with asking officers for an extension of time, so getting more time than just the 3 business days, and they tend to work with us. I've had that in other jurisdictions as well. So it's just important to get counsel involved, really do the record review before you're turning everything over to the U.S. government.
And then the fourth one is performed usually in connection with an H-1B and L-1 sponsored employees. It's an unannounced visit with the aim to detect or investigate potential fraud and abuse of the immigration process. Technically, it's voluntary. Consent's required to enter non-public spaces, and we'll talk about that distinction and why it's important in just a minute. But if the employee, and this also occurs in the remote context, we were talking about this over lunch, what do you do if you have a remote employee? And again, an employee doesn't have to allow somebody into his or her home. They can make arrangements.
Yeah, so what we've seen, these are on the rise. We've seen them occur more frequently, and similar to what I was saying about the work sites changing with H-1Bs. There's a lot of folks who are working remotely or in a hybrid capacity, and so those addresses are present on the H-1B petition, on the LCA that you need for the H-1B. So they can pop in at someone's home, knock on the door and it's unannounced. I've heard of it a few times. I wouldn't say it's all the time. I think a lot of times we're seeing a reach out first, either via email or a phone call. We've seen officers meet. I heard of one happening in a parking lot, which sounds very, very suspicious. But I've had some where they all meet at a work site that's relatively close to the individual's home, even if it's not one that they're working out of. So they can call, they can email, they can show up in person. There's no advance notice required. If an employee is not available that day, like if they do go to the work site and they're on PTO, or maybe they stepped out for lunch, generally the officers will, reschedule, come back later. But I do think it's important to know that this, similar to like the administrative warrant, does not give them the authority to enter into private space. So if they are at the work site, you can meet in a conference room. They don't have to be brought back. They don't have to get a tour. They don't have to see the person's work site, their actual desk or office. I've had clients say, well, I'm happy to go back there and take pictures. and I can send them to you, so you can put those in your file. That tends to be okay. And when they appear at someone's home, that I think is jarring, to have an officer show up, but they don't have to let them in the door. They can just say, they could meet with them on the porch, or, can you meet me at the coffee shop in 15 minutes down the street? So they can speak to the officer and try to coordinate something that's more comfortable.
So we have a recommendation regarding a response plan. There's been a lot of concern, what do I do if ICE shows up? And it's always wise to have a response plan. That response plan should include that front desk, receptionist, point person. And as you think about your workspace and where somebody would enter from the outside, who are they most likely to come in contact with? That designated person should also have designated points of contact within the legal and management team. So if ICE shows up with a judicial warrant or with an administrative warrant, that they have individuals that they can contact immediately, and it should be legal and management. And what we would advise is that you have invite them to sit down, and that you're going to contact that you don't have the authority to consent on behalf of the company, have a seat. I'll get someone down right away to deal with that. But they should at least know and understand sort of the different warrants that could be accompanying that officer, and then how to respond, and most importantly, who to contact. And then, of course, the points of contact should have the name and phone number of the company's legal counsel. Contact the company's counsel and management team immediately should a warrant be prescribed at the facility. And I think we have talked about and we've heard about, and I think it gets a lot of play on the news, where, armed officers are showing up, they're going to execute a judicial warrant. And again, the initial contact person for your company can ask them to sit down, but should not in any way obstruct or get in the way of the execution of a judicial warrant. If doors are locked, unlock them. And the other thing that is important to know is that you can take notes and you can film. Somebody wants to film on their phone. I asked today, I said, well, what if that's considered obstruction, or what if they say put the phone away? And I think your advice was, well, put the phone away. So, and that highlights sometimes in the heat of the moment when this is going on, you want to keep your employees safe, you want to keep calm, you want to keep things as manageable as possible. If there are violations, certainly on the other side, once the warrant is executed, once it's over, then there may be legal challenges that you can make, but we would recommend that when requested, stop filming, or if they're not going to wait and they want to execute the judicial warrant, do not get in the way. Here's a sample procedure of the steps to follow. Again, when ICE appears, it may be a situation where they present their credentials and hand over the warrant, but if not, you're going to want to request identification and governmental credentials, then immediately reach out to the designated points of contact, confirm whether the government agent has a judicial warrant, and if the agent does not have a judicial warrant, the agent's access should be limited to a reception area or an adjacent conference room, and the agent should always be accompanied. Again, because that administrative warrant requires consent. During the worksite enforcement action, do not discuss the company's policies or practices or answer questions. You may ask if employees may leave or if they're being detained. An employee should not be detained for an unreasonable amount of time without probable cause. Inform the agent of any special needs that the employee may have, medical, child care. Unlock any locked facilities to which the agent requests access if a judicial warrant is present.
One real quick note, too, on this. if someone is detained. Like if, you know, you can tell the officer's going to detain the person and take them from the work site, you can ask, or someone can ask the officer where they're being taken to so that you can communicate with their family. So I would recommend, you know, as you train up folks internally, that if that does happen, that they do ask those questions so you can at least share it with their family and they can get legal counsel.
Which also raises the point that you probably should have up-to-date emergency contact information for your employees.
Yes, yes.
Again, as I emphasized earlier, remain calm, instruct employees to do the same. If a government agent enters private areas with or without a warrant, an employee can be assigned to follow them, like I said, take notes or make recording. Observe the agents to ensure that they're complying with the warrant scope. And do not block, interfere, obstruct with the agents. And again, we talked a little bit about public and private areas, and that matters, again, depending on the warrant, but with an administrative warrant, officers are not allowed into private areas. What are private areas in your business? It's essentially places that the public cannot access coming in off the street. If I were to come in off the street and walk into the reception area and the lobby area without, you know, having to receive permission, that's going to be a public area. And officers can enter into that public area and stay in that public area if they do not have a judicial warrant. Private areas, however, are off limits. So private signs, you know, either you have private area, do not enter posted, or they're locked. If you have a reception area where you walk in, but there are offices off of the reception area, you may want to just shut those doors. But you do, and you can hang signs designating what is private and not private areas. And we recommend that if you have private areas that are readily accessible to someone, to put a private sign on it, shut the door. If it has locks, lock the door. And make sure that those areas are designated and stay private. That could play a very important part should ICE visit with an administrative warrant. Any questions?
I have a TPS question, if you can help with that.
I'll do my best.
Okay. We've been hit with TPS revocations, which has been devastating to the business. Are there any more foreseen revocations that could impact businesses? Do you guys, I mean, based on the pattern, which has been up and down, I know, but based on the pattern, is there anything that you foresee that you can be like, yeah, this could be a sticky point in the future?
I think the ones of most concern have probably been hit, but at the same time, I feel like one thing within this administration is unpredictability. So yeah, TPS has been really rough. I mean, for employers, for the individuals that are in TPS, just having the rug pulled out from underneath them when they were here legally. And I know employers have really been struggling with that. You know, if you're E-Verify, you run the reports, you see whose EADs have been revoked, and or they come to you, you know, asking for assistance. They got a notice, their work authorization's gone, and it's been a roller coaster. I mean, the TPS for Venezuela has been all over the place. Yeah, I mean, the best thing to do is, I mean, as much as you can, just to stay on top of that space. We have some great resources. We have a new administration resource hub through our firm. We also have Ogletree Insights. That's basically blogs, but our blogs have blogs. We blog on everything, so we try really hard to push the information out to our clients and employers as fast as we can because it's ever changing. And I'm sorry to hear that you guys have been hit so hard.